All right, hello everyone. My name is JC Bryla, and on behalf of IBI, I'd like to welcome you to this webinar. Before we begin, I'd like to thank you for attending. IBI has been hosting a series of forum webinars, which are features of presentations that were hosted in our agenda at the 2016 IBI Annual Forum in San Francisco. A few notes for our attendees before we begin. First, this webinar is being recorded and will be available to view and share on our website in about a week's time. Second, we'll be putting the PowerPoint presentation up on the website as well by the end of today. If you have any specific questions, please reach out to any IBI staff, where our contact information can be found on the IBI website. All attendee lines except for the speakers will be muted during the webinar due to the high volume of attendees in the recording. If you wish to ask a question, please use the question function within the panel on the right side of your screen in the webinar software. The presenters will be answering questions at the end of their presentation. However, we encourage you to type the questions in the question box during the presentation if you wish. IBI is especially excited to host this webinar titled Overcoming FMLA and ADA Challenges, a Case Study in Absenteeism Improvement. And we hope that our members and non-members alike can learn and utilize the information presented today and receive any feedback for presentation, the speakers, or any IBI information that you receive today. Today's presenters will be Matt Morris, who is Vice President of FMLA Source at ComPsych, and Marjory Robertson, who is Assistant Vice President and Senior Counsel at FMLA. And with that, I'll be handing this over to Matt.
Great, thanks, JC. Give me 1 second to do that. Okay. Marge, can you see my screen?
Yes, I can.
Now, okay, great. So we're cooking. Well, thank you everyone for coming today. We understand we have a record-setting number of attendees registered today, which is very exciting. We've alerted Guinness Book to this. The subject and the title today is Overcoming FMLA and ADA Challenges. So we're going to be focusing quite a bit on absence management and the challenges inherent in it, although it's a little different from many of the other IBI programs that you may have attended in the past. And by that I mean, IBI is this cutting-edge organization with regards to workplace productivity, health, and wellness, particularly also as it relates to absence management and getting people back to work. That said, we're going to be focusing on a lot of the sort of the legal parts to this today, because none of that other stuff, which is all very good, matters if you're breaking the law while doing it. So what we're going to discuss are not as much the benefits that can be employed to return people back to work, but rather the foundational rights and responsibilities that you need to follow in order to then move to effectively improving your workforce health. So in terms of an agenda, we're going to start with a baseline of what the problem is. Now, some of you may be groaning out there because you may be well aware of how much everyone hates the FMLA and ADA and these laws, and we want you to, but not everybody does, and we want you to be able to join our club. So, but we'll be quick on that, we promise. And then we've broken the rest of this down, as you see there, the current and challenging issues, into what we see are the 4 main issues that have affected employers in absence management over the last couple years, and particularly the last 12 months. And those are compliance, as it said, so understanding compliance obligations, especially across several sites and with ever-changing federal and state obligations, oversight, and this is a new one. We're going to spend a bunch of time on this. Really, it's we think caused by a decentralization, lack of consistency, and control and having people who are making decisions that are not absence management experts. We're going to talk about the ever-present issue of intermittent misuse, and then finally talk about the ADA, which, as most of you know, has become a huge issue over the past few years, and a lack of inclusion of the ADA within the leave process and what issues that creates. And then we should have enough time for questions. We'll do those at the end, but everyone should see a question box in their GoToWebinar, and so please feel free to type those in there as we go, and then we'll address as many of them as we can at the end. But first, I want to turn it over to Marjory and to talk about, again, what is the fuss about when it comes to the FMLA and ADA.
Thank you, Matt. And just to give people a heads up, we'll probably be switching back and forth just to keep you on your toes. So what is the fuss about? Well, the FMLA and the ADA have become increasingly more difficult to comply with over the past 10 years. I think that can be attributed to a number of things. One is there's been very liberal administration, and so the two agencies who enforce these laws, the Department of Labor enforces the FMLA, and the Equal Employment Opportunity Commission enforces the EEOC. They've been taking more and more aggressive stances. The courts have also become more open to these types of claims. I think that can be attributed in part to the fact that the 2008 amendments to the ADA were intended to send the message that at least the ADA should be interpreted broadly. So some of the challenges on the FMLA side that we're going to spend some time talking about are calculating the time taken, analyzing the reason for the leave, which includes identifying whether it's an FMLA leave or not, dealing with that nightmare of unplanned intermittent leave, and I would add in, echoing what Matt said on the prior slide, dealing with potential interference claims based on statements or conducts by managers or HR who may not be completely sensitized to some of the legal issues. And in the ADA, the challenges are that there are no clear rules. What is a reasonable accommodation is a very fuzzy determination. There are no standardized time limits for leaves. You know, the FMLA is so clear, it's 12 weeks. There's certain eligibility rules. None of that is applicable for the ADA. And then there have been very large settlements, both of cases brought by employees as well as investigations brought by government.
So that's the background. And then, you know, how have employers solved for this? Well, there's a few different ways. One is to keep it in-house and to sort of breed the expertise in an HR department, in legal. There are polls taken every couple of years that I've seen that ask how many different sorts of roles get involved, and it ends up being about a dozen different types in an in-house solution that end up helping to manage this. What that's required of organizations is a lot of additional expertise in-house, not to mention systems and letter generation and so forth. We've seen co-source solutions, which is really about keeping it in-house, but bringing in other solutions like software to help employers navigate this. And then what we see and what, you know, our organization does is a fully outsourced solution on leave, on disability, on ADA. About half of employers report outsourcing some or all of their FMLA, and we thought it was interesting too that this site from about 10 months ago from this study that said 40% of employers expect the importance of outsourcing an FMLA and ADA services to increase. And I think what that's saying is a couple things that we're going to touch upon through this. One is that employers are just at this point crying uncle and saying, it's too much, we can't do this effectively anymore. The DOL, as Marge mentioned, and the EEOC, their enforcement is too severe. the changes are too great, the risks are too high, our HR departments are too small, and so forth. And then the other piece, I think, is we're out of this kind of early adopter phase in the life cycle and into a majority phase where this is more commonly seen. And just as we saw, a decade or even more ago with benefits, retirement benefits in particular, or payroll, those portions of HR being outsourced, that we're now seeing that in absence management as well. So now let's move to the first of these 4 challenges we want to talk about. So IBI itself did a survey last year, and I think the way the question was worded is, what keeps you up at night? And what was tied, at least for the winner, was FMLA and ADA compliance. 43% of the employers voted for that. I think the other 57% were just very heavy sleepers. Employers said that this was very important to their efforts to manage their workforce health and productivity, beating 15 other choices. So why is that? Well, there's 2 main reasons. One is the complexity, and Marge already talked about that a little bit. All of the different elements of the FMLA, determining eligibility, reviewing the medical certification, understanding entitlement, especially with those intermittent leaves where 12 weeks can get as granular as a minute. And ADA doing things like determining reasonableness and having the subject matter expertise on that. And then there's change. Marge is going to talk about the change at the state level, but at the federal level, we've had transformational case law. The Supreme Court last year changing the definition of or confirming in some cases the definition of marriage, which changed how an employee under the FMLA can take a leave, and then especially when it applies to the employee's spouse. And then we see the lower courts all across the country, and when we cataloged this, it was about 2 cases a week that really help inform the way an FMLA or ADA practice should be administered.
So as Matt alluded to, there has been a phenomenal amount of change legislatively at the state and also the local level. And those changes have really been in 3 different areas. The first are pregnancy disability accommodation laws. I believe they're more and more frequent, and I think they are a direct response to the Supreme Court's decision in the case of Young versus UPS. And in that case, the court discussed the current federal law situation and said that pregnancy itself is not a disability. Complications from pregnancy might be a disability. There is the Pregnancy Discrimination Act, but that does not actually require employers to affirmatively accommodate women who are pregnant. It simply provides that employers cannot treat them worse than they treat other employees or discriminate against them. And in Young versus UPS, the court did not say that employers have to accommodate all pregnant employees, and they didn't even say they needed to be treated equally. But they did say that the employers have to have a really good reason if they're going to provide, for example, a light-duty job for somebody who's injured on the work, but not for someone who is pregnant. Well, many of the states don't think that goes far enough, and they have adopted pregnancy disability accommodation laws that affirmatively require employers to offer accommodations to women who are pregnant. And that definitely goes beyond what the federal law currently requires. The second big statutory area is in paid family leave. And there are 5 states, though one is unfunded, that have the law. There are active bills in Connecticut, District of Columbia, and Massachusetts. There's one city, San Francisco, that has the law. These laws basically provide a certain amount of income replacement over a period of weeks, often mirroring the time period of the FMLA leave and often for the same reasons. Until recently, I think these laws have not caused employers as much consternation because they've been employee funded. But the two new laws that are pending in District of Columbia and Massachusetts, I think could represent a sea change in that area, because those laws will require that employers fund these paid family leave. Another interesting thing that is happening is that more and more employers are offering paid family leave that the employers are paying for, even though it's not required by any federal, state, or local legislation. The reason behind this is that a lot of focus has been paid to the fact that the United States is the only industrialized country that does not have paid family leave. And so I think there is more and more employers are seeing it as an opportunity to make themselves a differentiator, and I do think this is going to be a major area of change over the next few years. And then the last legislative development is paid sick leave, which if you read the paper, you see it. I actually, since we did these slides, I've become aware of some more changes, including my understanding is that in Chicago, where Matt is, the full city council is voting today on a paid sick leave law that has already been preliminarily approved, and it will then go on to be signed by the mayor. LA, San Diego have also recently adopted paid sick leave laws. These laws, there's 5 states and many, many cities and counties. These laws can be intimidating, but they actually have some common elements to them, and Sun Life has prepared a compliance piece called Common Sense Compliance with Paid Sick Leave, which if you're interested, there'll be a contact information at the end. You can ask for it. But the message of that piece is, yes, these laws are all over the place, but they have common factors, and all of them say that if you have a PTO policy that meets the requirements of the laws, you'll be deemed to be in compliance. And I think that there is a way for employers who operate in a number of jurisdictions to have, it's not guaranteed protection, but it goes a long way towards protecting you if you have a PTO policy that calls out a number of the important issues. And the paid sick leave, what they offer for employees is a certain number of paid hours, 24 hours in California, although you double that if you're in LA, 40 hours in Massachusetts, that you can use for your own illness, the illness of a family member, or even for routine medical appointments. So that is the hot legislative development.
So, and you're right, Chicago is voting today. I think everyone thinks that will pass and that we will have that soon enough. The next challenge we want to talk about is this oversight. And this one is interesting, is the most interesting, I think, of the 4, because you hear a lot about intermittent leave, you hear a lot about compliance, and certainly the ADA has become the most kind of current anxiety producer amongst people in this industry. Oversight has always been an issue, and when we say oversight, we mean that the employer's ability to manage this through their HR and manager staff. But it's always been sort of an issue, but what we've really seen is this uptick, at least in terms of what's been happening in the courts over the past 12 to 18 months, and we'll sort of walk through that. But I think we're not the only ones to notice that, as the DOL seems to have noticed that themselves.
Yes, in May of this year, the DOL issued something that people have been waiting for a long time. It's the Employer's Guide to the FMLA. I actually highly recommend it. I was surprisingly pleased to see that it's quite user-friendly, almost, I wouldn't go so far as to say entertaining, but it was a much easier read than I thought it would be, and it's jam-packed with information. It's organized in a way that's easily accessible and addresses eligibility, qualifying reasons, the complicated certification process. It's got a great section on military leave. You can get it off the website. It's a free, great resource.
Yeah, having said that, just for those of you that are concerned and think there's 75 pages of new rules, none of it is new. So it is just sort of a restatement of what are fairly wonky regulations and the law, and done in a very user-friendly way. But it is, to Marge's point, I think a very good resource for employers as they try to make sure that they're administering this correctly. So what is this responding to? There's a few things, and I don't know that this is directly based off of what's been happening in the courts, but why has this become a bigger issue? Again, especially since nothing particularly different happened in the law with regard to employer obligations on this oversight. Well, there are a few things that are interesting. First, in the last 2 years, the economy has picked back up. People have moved into new jobs. More millennials have entered into the workforce. They are new to the workforce. They are new to employment laws are new to them. So there are different people to train now. There are certainly still fewer HR resources. I think we all know when the recession hit about 8 years ago, HR departments, especially leave administrators that were built into HR departments, they were gutted, and a lot of those people not only were let go, but they weren't brought back in the last couple of years. Organizations, as I say on the slide, have been acquisitive. So you may have an organization that has been in Texas, and now you're buying a company in Oregon, and now you have to learn does that Oregon, for FMLA, does that Oregon work site or work sites have 50 employees for purposes of the FMLA? What is this Oregon Family Leave Act, and how the heck do I administer that? So all of those different pieces being troublesome as well, and also just having different having HR sort of manage different work sites and different employees at those work sites are tough. And you see there in that blue box that, again, the surveys are showing this. 40% of employers saying they have trouble making leave decisions, 47% keeping accurate attendance, and 44% of employees saying training supervisors is extremely difficult. And what we're going to see out of that are the results in the cases. But before we get into the cases that sort of have also transformed this case law, just a few that we've seen literally since the beginning of the year in January, and these are ones where you can actually see a judgment. A $502,000 judgment against a medical organization, and that was because when they asked the manager why they didn't give this employee who was suing Summerlin this nursing job, they couldn't answer that. The judgment of $502,000 would have been higher if the employee hadn't gotten herself a new job. There was another case called Engstad, which was from a year ago. The employee needs leave for his sick wife, and no one tells him this is FMLA. The employee wins $275,000. A restaurant chain earlier this year that won $600,000, or lost $600,000, I should say, because of employees who had sued. A university that had discouraged full-time faculty earlier this year, a $710,000 judgment. So these are huge, huge issues. And what we see here is a lot of times what's happening is these management issues are happening at the joints of this law, where there are very subjective provisions. And not only is that creating issues for employers, but it's creating this vicious this cycle where, because there's ambiguity in the law, employers make decisions, they deny employees, they get terminated. Those cases those situations end up turning into court cases where the judge or the court is actually then not only interpreting the law, but transforming it a bit by making new law that employers then need to follow. So you'll see that as we then go through these situations that have happened over the past few months.
So we're going to talk about a number of types of cases involving conduct by managers in HR, sometimes well-intentioned, but that do run afoul of the law, including situations where a termination decision is tainted because it is tied into the employer's or the manager's feeling about FMLA leave eligibility. where managers knew the leave was happening but didn't report it up so that it didn't get treated in accordance with FMLA requirements, where managers have made improper comments that has led to interference claims, where they've had enough information to know there was a medical condition but didn't do anything to ensure that FMLA notification and other obligations were complied with, and where employers have improperly contacted employees during the leave.
So we're going to go through these relatively quickly because and the main thing is not to remember each one of these cases, but as you see the mosaic of all of these cases, you can kind of see the impact that these are causing. The first category is where managers or HR kind of tainted the decision. The Smothers case is one in which there was a mechanic. He had a disability that created a situation where he couldn't sleep. Management wanted to fire him because he was a safety risk. Seems like a pretty legitimate reason to make an employment decision. The problem was that because HR wasn't as intimately involved, they never asked the question, well, what did you do with the other employees who were safety risks? And as it turned out, none of them, people without disabilities, had been terminated. And so that's where the employee won that one. The Graziato case has actually come out since we gave this at session at the IBI conference, and that has created a lot of ripples because in that case, the HR person was actually found individually liable, or at least it was going to go to the jury, going to a jury trial as to whether that employee was individually liable. In that one, the HR director very much seemed like she was discouraging the leaves of this employee who had two leaves, intermittent, each for a different one of her sons. She made the argument, and the employer in this said that she wasn't even making the decision, which is often the case, but it went even further where the employer said because this HR person played an important role and had sufficient control over the decision that she could be held individually liable. And then the next category, which is where the managers or HR knew of the leave, but they didn't report to the proper channels. In the Hudson case, that's one where there was a clear way you needed to report your time off. The employee clearly didn't follow the process, and the employer terminated him. But the argument that the employee made was, yeah, I guess that's the process, but what I always do is just text my manager, and that's always been okay. And the court there said that the manager's involvement by allowing that text vitiated the main policy and ruled for the employee. And then the Preddy case is just one in which there was a school district, the employee had to take leave for her child, and they said, you know, this is how you follow our leave process, but she fell through the cracks. No one ever followed up. She ended up getting terminated, and obviously, in that sort of case, won. The last thing I would say about this Graziato case and the individual liability is it's not a new phenomenon. There have actually been 3 cases that I know of other than this since 2009 that have all said the same thing, which have allowed individual liability for purposes of against the HR person herself.
The next series of cases relate to 2 areas. The first is managers making, or HR making, improper comments, and each of the cases quotes some of the comments. I want to point out some really important legal issues that are discussed, particularly in the Janczak case. It's a wonderful decision. The court there talks about the difference between an FMLA interference claim and an FMLA retaliation claim. An interference claim is where the employee is saying, you didn't let me take my leave. You fired me before I finished it. You didn't let me go out. And retaliation is where an employer actually lets the employee go out on leave, and then something bad happens to them after they return. It's really important to bear in mind that the Janczak court and others have said that the burden of proof is different for those 2 types of claims. For the interference claim, courts have said it's the employer who has to prove that what they did not violate the FMLA. And for retaliation claims, courts have said, in contrast, it's the employee who bears the burden of proof. The Hefty court put it a different way. They said for retaliation, an employee actually has to show intent, which they don't have to do for an interference claim. So as a practical matter, employers might want to think about if they have an employee with performance issues or conduct issues, you may want to think about allowing them to take the leave and dealing with the issue when they come back so that you will be in a better position from a legal point of view. The Arroyo case is interesting because it talks not just about FMLA and ADA, but also USERRA leave. And in that case, the employer, the manager, kept making remarks about how the leave was causing an undue hardship. And, you know, that's a fair concern, but legally it's not an appropriate concern. Under USERRA, just like under the FMLA, if you're entitled to the leave, you're entitled to take it. It doesn't matter if it's an undue hardship. And so having a manager make comments about it can make it seem like the manager is attempting to interfere, actually interfering. In the Arroyo case, there were also comments, gratuitous comments made about the manager not believing that the employee was really out for a medical reason. The manager said, oh, I think she's on vacation in Hawaii. Those kinds of comments can lead to problems. The second area of cases are where managers had enough information to know there was a medical condition but didn't do anything to properly advise the employee of FMLA rights. The Festerman case is interesting because there the employee actually quit work, and yet the court still found liability as a constructive discharge. In that case, he had had a medical condition at work and came in later with a doctor's note, but the doctor's note didn't really go into any detail about what the medical condition was. And the company had a policy that said to start an FMLA claim, you have to actually file for one. But the court said, well, there was evidence that in the past managers had accepted doctor's notes as being enough. And so in that case, they determined that should have been done for this employee as well. This was another case that involved disparaging comments. It wasn't the manager this time. This time it was a coworker who came in with a T-shirt saying, I have a note from my mommy. And it was clearly designed to poke fun at the employee who had gone on leave, and that was held against the company in that case. And then the wages case is fascinating to a lawyer, maybe to nobody else, because the court granted summary judgment to the employee, which rarely happens. Usually you see the employer getting summary judgment. But in that case, the employee who was pregnant had come in with some doctor's notes initially saying she couldn't lift, she couldn't do some things, and then the last one she brought in said she needed to work reduced hours. The employer had accommodated the first few notes, but then at the end said, look, this is interfering with the essential functions of your job. We can't accommodate this, and they terminated her. Well, under the FMLA, the fact that something interferes with the essential functions of a job is irrelevant, and it is not a defense to denying somebody their FMLA leave rights. And so the court said, look, we don't need to send this to a jury. There's no way that the employer can come up with a good excuse for what it did. On the next slide, talk briefly about contact that employers can have with employees during leave. It's not a no contact rule. The Smith-Jenk case is very good at going through what the legal requirements are, and essentially de minimis contact is allowed. So if it's modest, unburdensome, occasional, in that case, the employee had worked 20 to 40 hours during the leave, and that was determined to be too much. In the other two cases, the courts ruled in favor of the employer. The second one, the Krause case, is particularly interesting because there the employer did an investigation about whether the employee who was on leave had actually engaged in fraudulent conduct. And the court noted in passing, well, the employee never said that she didn't want to participate in the investigation, so there was no real evidence that the employer had forced it. My recommendation, again, because of this burden of proof difference between interference and retaliation, is that you may want to hold off on an investigation like that until after the leave is over.
So the moral of the story of this, there's many ways that a good process can get screwed up. And let's not blame the managers. You don't hire managers to be FMLA experts, I guess, unless you're us, and that's what you do. But you want to get managers out of the process, and as we talked about at the beginning, why has outsourcing become so much more attractive? Because you can train managers to then just say, look, call this number and leave me out of it and get them out of the process because they don't need to be involved. And what happens when you don't? Well, there was a DMEC survey from last year that highlighted this. 44% said that training supervisors was extremely difficult, and 37% relied on managers for leave enforcement, and that was an extreme problem for them. So that kind of concludes this section of oversight. Again, I would expect nothing differently has changed this year, and like the Graziato case particularly, we're going to continue to see challenges with good policies, good processes, but not good execution on them. The next thing we want to talk about is, again, the most common problem here, at least that employers point to within absence management, and it's intermittent abuse. It really pins down to unplanned intermittent leave. Every survey, every time by any employer, you ask them, what's your biggest issue in absence management? They'll say unplanned intermittent leave. So what's not to like? Well, it's difficult to challenge the usage. It's self-reported. So how do you know whether an employee is really sick? And that can breed abuse. The increments can be as small as a minute. So it's very hard to track this. It's time-consuming to do all of that tracking. It also creates morale issues. These morale issues have been actually reported to the DOL in requests for information, where employers say, look, when we have a department, and I'm sure many of you feel this, where a lot of people are out on intermittent leave, the good kids, so to speak, that are not abusing are feel like they have challenges. A lot of our clients have that. And what they're saying is, I now have to not only do my job, but the person's job that is abusing the intermittent leave. And to be clear, intermittent leave is a critical component of the FMLA. And for illnesses such as back pain, behavioral issues like stress and anxiety, migraines, asthma, it's critical to an employee's ability to continue to do their job, and it is an essential right that they have. But you see there that most employers, or many employers, see this as not only as disruptive, but a place where employees are misusing the leave. So what are the legal developments on this over the last year? Marge will talk to that. Not as many, certainly, on this because we see this, but certainly very impactful cases with regard to intermittent leave.
Right, Matt, that's exactly right. There's only two, but boy, employers are not going to like them. The first is that once somebody gets medically certified for intermittent leave, managers cannot be asking them to bring in a doctor's note every time they have an intermittent episode. It's only one medical certification. There are some remedies, which Matt will talk about, but requiring a doctor's note is not one of them. And the second is that you cannot discipline somebody just because the number of absences they've had has exceeded the estimate that's in the medical certification. As one court pointed out, it's only an estimate. So there is a tendency for managers and HR to get concerned when the absences are more frequent, and it's not unusual for them to be more frequent. There are some remedies, and if we turn to the next slide, you can discuss those, but disciplining them for the excess is not appropriate.
Yeah, so what can you do? I mean, there are remedies or challenging mechanisms within the FMLA, recertification, which is going back to the same doctor and asking about the particular of the way the leave manifested, clarification and authentication on a certification, or second opinions. But second opinions are really about does this person have this condition? And what we find most often with intermittent misuse is it's not whether the child has asthma or the employee has stress. It's how they use the time. And second opinions are ill-equipped to speak to that. I certainly think I see programs all the time about that tout the ways in which you can fight back. I will say generally these are less than optimal. But what else can you do? First of all, you have to use your data. You have to understand when employees are taking leave, how that is working. Are there patterns? Are they overusing? That Hansen case that Marge talked about said it's only an estimate, but yet if you significantly exceed the frequency or duration you're approved for, you can certainly, the employer can certainly recertify that. And make sure you're using your benchmarks. IBI is the name of the game in terms of having benchmarks on absences and being able to understand whether or not you're within the right parameters. And then use benefits. I don't mean to be so negative about this. Employees, again, do struggle with these conditions. So make sure that if you have employee assistance programs, disease management, work-life programs, that you're offering those to employees so that they understand that maybe there are alternatives to taking leaves or ways they can ameliorate them. So we're getting a little low on time because we want to make sure we have enough time for your questions, but certainly we want to make sure we touch significantly on ADA leave as well.
Okay, so we're now going to spend some time talking about mostly ADA in the context of absence management, which is for leaves, but we'll hit on it more broadly as well. Some people say the ADA is the new FMLA. It certainly applies more broadly than the FMLA. It applies to employers with 15 or more employees. It protects employees from day one. It protects individuals from being subject to discrimination, and the ADA is a powerful law because it not only requires you not to treat somebody badly, it actually requires you to treat disabled employees better than you treat other employees. The only other two discrimination statutes that are like this are religious discrimination and military discrimination, where you're actually required to do an accommodation. So next, the ADAA.
Yeah, and so what happened a few years ago was I'm sure many of you heard of the ADAAA. It's really the ADA and the ADAAA are really all one and the same now. These were just amendments that were made to the Act. What did the amendments do? They made it so that there was an easier time for employees to show or prove that they had a disability. And by having more employees who can have a qualified disability, that then rolls downstream to say there are more employees who then can have a reasonable accommodation of that disability. And therefore, as we're talking about as relates to this program, that means that could also include leave. Do employers struggle with this? I think this slide sort of suggests yes with an exclamation point. And 55% of employers saying interacting with this FMLA and ADA together is extremely difficult. 69% saying ADA was challenging. And this was from our own study about a year and a half ago. A lot of this springs forth from employers having old and bad language in their policies, their leave policies, that doesn't account for the fact that somebody may have ADA. And we'll talk about the multi-million-dollar settlements that have arisen out of this, but where those cases start from quite often is after a complaint is filed by a particular employee, which they can do without a lawyer, by the way. The EEOC gets the policy and sees that there are automatic cutoffs at some point, some as long as a year of leave, after which the employee is no longer entitled to their job, and the EEOC is suing on that behalf. it's become such an issue that you see on the right-hand side of your screen that just last month they issued new guidance to make sure that employers understand their rights and responsibilities under the ADA with regard to leaves of absence.
So what do employers have to do? Well, the most important thing is they have to engage in what is called the good faith interactive process, or a good faith interactive dialogue with an employee when they become aware that the employee might need an accommodation. Important to bear in mind that the employee doesn't have to use any magic words. It's like the FMLA. They don't have to say ADA or accommodation. If they have a medical condition and it's interfering with their ability to perform jobs, you may have an obligation to engage in the interactive process. Good idea. I actually, here at Sun Life, I advise managers and HR. We have a form memo that we give to employees once we become aware that potentially the ADA or the FMLA could be involved, to prove that we're willing to get involved in this good faith interactive process.
And then, so what are the gaps? There are many. Courts saying there's no obligation to invoke the ADA, like Marge just said. No obligation to even make a request for an accommodation. Where the leave is obvious, the employer has a duty to start the interactive process. In some cases, you can't require medical in those situations. When is something obvious? Another place of ambiguity within the regulations. These leaves can go longer than the 12-week period and so on. But really, what we want to focus on are two main issues here that employers have had. One, issues in terms of administering the ADA as a leave. So the first thing we want to focus on is the integration of ADA into an FMLA program, connecting the two, or if you like, it's just about thinking of the ADA as a leave law as well as a non-discrimination law. And then the second, even when employers understand that and have built their program as such, they're left shrugging their shoulders even after this guidance from last month saying, but how do we have the expertise to make these correct decisions? So the first thing we want to focus on is that integration.
So on this slide, there's reference to the inflexible leave and 100% heal cases, which we actually have a slide coming up that goes into those. So I think I'm going to save the discussion for those later, but that is a huge area. What I want to talk about is the second bullet, where the ADA and the FMLA overlap, but there are some really important distinctions between them, and there are a couple of cases that I think really drive that home. One is mentioned here, and one I'm going to add in. Mandatory overtime. So there have been FMLA cases where an employee, for example, had a migraine and the doctor certified that working mandatory overtime could trigger the migraine, and courts have said that they can use intermittent leave so that basically they can get out of having to do mandatory overtime. The analysis is different under the ADA. Under the ADA, if somebody either hasn't worked there long enough, or they've used up all their time, or they don't work at a site that's big enough, and they want to get out of mandatory overtime, then the employer is allowed to say, well, wait a minute, it's an essential function of your job that you work mandatory overtime, and we make everybody work it. We don't make exceptions for that because it is so essential. In that case, an employer may not have to accommodate. So if the FMLA leave is available, the fact that it's an essential job function is irrelevant. A great case that I love about this is it was a case I found about sleeping on the job. And I will say that as the employer advising Sun Life, we've had situations of employees sleeping on the job, and I've helped managers write memos that say that staying awake at your job is an essential function of your job. And if you're doing an ADA analysis, that's a great argument. I think very rarely under the ADA would you be required to accommodate that. But in this case, the court pointed out, well, wait a minute, this employee might have FMLA leave available. It was, again, an employee with a migraine. The employer had an area where employees could go rest, and she went and took a nap, didn't tell anybody. And the court said it was conceivable that she could use intermittent time for that. The court ducks the issue by deciding the case on the ground that she hadn't given anybody notice and nobody knew where she was. but it highlights, again, that key difference that the FMLA leave right is absolute. The fact that it's inconvenient or involves an essential job function is irrelevant.
Then we wanted to talk about what are these big cases. I think people have heard about the Sears case for years, but the EEOC is suing employers in many cases getting these multi-million-dollar settlements, and they're coming in kind of two different flavors. Marge is going to talk about inflexible leaves, and then I'm going to talk a little bit about the 100% healed cases.
Right. So the inflexible leave cases typically involve policies where employers say after a certain period of time you've been out on leave, we're going to terminate your employment. That was the most recent one was the Lowe's case, which was an $8.5 million settlement. But it can also involve employers who have policies such as we don't give leave to probationary employees. So any kind of hard and fast rule like that is going to be problematic because what the ADA requires is an individualized analysis.
And then the 100% healed cases are almost the flip side of that. It's saying you need to be 100% healed before you can come back to do your job, and that's this sort of monolithic, inflexible rule. And what the EEOC then says is, hey, you need to at least consider whether there's some other way to bring that employee back. You don't necessarily have to, but if you're not going through the consideration, that's a problem. And the one to point out here is the fourth bullet, this interstate distributor company. That was a trucking company, and what's relevant there is that was an 1,800 employee organization, and they were hit with a $5 million or almost $5 million settlement. That's quite a wallop. And just to say it, it's not just these monetary settlements, but the EEOC will enforce what's called a consent decree, which allows which forces the employee to basically be under the employee's thumb for however long, but it's usually between 2 and 4 years. In the Lowe's case that Marge referenced, it was not only 4 years, but they were forced to bring in a consultant, report regularly to the EEOC on data on their progress and other obligations. So that's kind of the integration point. But again, even once you have integration, you need to have expertise in order to understand the way these laws work. We've seen many employers get into trouble because they've just made a gut reaction as to whether or not an accommodation was reasonable and not really looked at their obligations under the law itself.
So now we're going to look at some recent cases in key areas, and the first series involves examining situations, whether they are disabilities, pregnancy-related conditions, temporary conditions, or stress caused by a manager.
And given our time, I'll try to go through this pretty quickly. Do disabilities include pregnancy-related conditions? Marjory talked about that a little bit with this Young versus UPS case. It's not under the ADA, but really, for all intents and purposes, employers need to consider pregnancy-related disabilities for purposes of accommodation. And then historically, with the ADA, temporary conditions were not seen as requiring an accommodation because a temporary condition was something you healed from. It wasn't a disability. And in the Summers case, the court there said that even somebody who was unable to walk for 7 months because of a broken leg, that was sufficiently severe enough to be qualified as an ADA disability. And then finally, the stress cases, some of these were kind of funny. The Higgins and Adatimahan cases were ones in which the employee seemed to be being told that they were doing a bad job, and they said, well, that's causing me stress. And when the answer was, well, what's causing you stress? The response from the employee was, well, my manager telling me I'm doing a bad job. There, the court didn't follow those and say that, in that case, the employer won, saying stress from an individual manager typically is not considered a disability, although the Palmerini case kind of cut the other way.
So the next area, and I think it's possibly our final area we're going to talk about, is what kinds of accommodations are reasonable, and including telecommuting, open-ended leave, flexible schedules, changing managers, and occasional absences. So the first area is telecommuting. I think that the answer to whether telecommuting is a reasonable accommodation is that depends. The Sixth Circuit some time ago in the Ford Motor Company case had a very broad decision where it said essentially, given the way technology is advancing, yes, it probably could be a reasonable accommodation. They've now pulled back on that, and in a recent case said, well, teamwork and being in the office are probably essential functions of most jobs, and so they indicated more reluctance. Basically, under the ADA, this is always supposed to be an individualized analysis. You look at this particular employee's job responsibilities and their medical issues and decide whether it's an essential function that they have to be in the office. Some cautionary words to employers: when you let some people work from home in a job position, it makes it really hard to argue that it's an essential function of the job that other people be in the office all the time. In addition, you can't take away, if you've decided to allow somebody to telecommute or you're evaluating whether you have to allow it, performance really shouldn't be a factor. The courts have said that if somebody is entitled to an accommodation, you can't take it away because of performance. You can monitor performance, and you can give them warnings, but you need to be careful using the accommodation as kind of more of an aggressive tool. The next slide talks about open-ended leaves. The courts uniformly do not have sympathy for open-ended leaves. In fact, on May 19th, 2016, the Second Circuit issued a decision in the case of Vangas, V-A-N-G-A-S, versus Montefiore Hospital, where they said that a request for an indefinite leave is unreasonable as a matter of law. With regard to flexible schedules, I call these the come-as-you-please schedules. You can have these where employees say, oh, I'm on medication, so I can't get in on time, or have other unpredictable absences like that. Again, courts aren't very sympathetic here. Many of them say that regular, reliable, and predictable attendance is an essential function of a job. I think employers need to be cautious about not allowing some people to have these erratic schedules and then not wanting to do it for the employee who is requesting it as an accommodation. But in general, I think that that's an area that it's easier for employers to defend.
So 1 minute on changing managers. As I mentioned, where the distress actually comes from the manager themselves holding the employee to expectations, that usually doesn't go over. Regular attendance is a real football in the courts. Mostly, courts have said that erratic attendance that affects the employee's ability to do their job cannot be reasonably accommodated. What does that mean? It means that you can't say, well, as the employee, well, I don't know when I'm going to show up, but you need to accommodate me and provide me with leave for that. But there is that AT&T case, which is a few years old now, which said, yeah, attendance is important, but is it really an essential function, which is a term of art under the law? So, all of this is, we want to get to questions in a second, but what are some thoughts and takeaways on this? There's many ways to solve this, but first you have to know what issues you have. You have to make sure you have ADA as part of that. Issues you have are also probably areas of turbulence within the courts and other guidance. So if you're struggling with these, it makes it worse because probably there are going to be court cases that help inform and potentially change this. Again, 2 to 3 potentially changes per week. At least that's what we've seen over the last year. You have to train your managers. Again, that oversight piece has become such a more hot-button issue over the course of the last year. Know whether you have intermittent issues or what issues you have, and use benchmarking, particularly through IBI, to use that and consider what options you have. And then make sure that ADA leaves, which, again, we continue to see employers just missing ADA leaves, that is a part of your absence management program. with that, I'm going to turn it back over to JC to start the question and answer provision. I know we're right at the top, or right at the half hour, but Marge and I will certainly stay on for a little while to answer some questions from you.
Yeah, so thank you, Matt, and thank you, Marjory, so much. Excellent presentation. I know we have a lot of questions. Just as a brief reminder to all of our attendees, you will be able to contact IBI, and we'll be contacting all of our attendees after the webinar, so you can get your hands on the webinar materials, both the recording and also the presentation, so we can quell some of those concerns. And then for more specific questions that you may have, feel free to contact IBI. We'd be happy to facilitate a discussion around any of the issues that were discussed in the presentation today. So to kick off the question and answer section of this, and by the way, if any of you need to hop off, feel free to. Like I said, this will be recorded, and you are more than welcome to share with us all of your colleagues and then revisit this. But I would like to ask a question on behalf of IBI for Marjory. IBI research has shown that employees who request FMLA time off for any reason, even if they are denied leave, are at a higher risk of a later short-term disability leave. How can employers connect with FMLA leave takers to programs such as disease management or return to work, lifestyle management, while still staying within the law and respecting their employees' privacy?
So that's a great question, and we recognize that that's what IBI is all about. As lawyers, both Matt and I, we certainly don't want to encourage or discourage employers from trying to do wellness-type approaches. I think that is a great idea. I think in general, you're not going to get into legal trouble for it, but as always, the devil is in the details. You need to be cautious of not singling out certain people to send them certain types of programs, information about programs, because for a disability claim, you could be accused of regarding them as having a disability. But certainly, it's probably best to have these handled through HR, not through the manager, again, because it can create that awkwardness in the relationship. But sending information, general information about other programs that might be of interest to the employee is probably not going to be viewed as any type of interference or retaliation. I think once you suggest it, you probably need to back off a little bit. I think being persistent about it is where employers could get into trouble.
Great. Excellent. Thank you so much, Marjory. And then I know Matt is preparing and reading some.
Yeah, so we have many questions. I don't think we'll be able to get through all of them today, given the hundreds of people that joined us today. But we'd certainly like to try to get through a number of them. So, Marge, I'll throw another one to you, which is, I think, related to that Hudson case. Would you say that managers and supervisors should not allow employees to text them?
Well, the problem is once you start allowing something, you're going to be held to allow it for somebody else. Or in a situation where you may not want to allow it. We at Sun Life, we have a specific call-in policy that people are supposed to follow. I can't guarantee that they always follow it. One important thing for intermittent leave, you can require people to call in and follow your procedures, but you need to ensure that you're following them too. So if you get a text message and you've told somebody you can't do it that way, I wouldn't completely ignore it, but I would remind them of the appropriate process for them to follow.
Yeah, I would agree with that. And also, keep in mind that even after this happened, that you would find that this was allowed. It's about doing an investigation. And if you are an employer that has managers that intrinsically involved in the call-off process, or even worse, the FMLA or ADA process, doing a full investigation to understand what happened there before you make the decision, I think is very critical to this as well.
Yeah.
Another question, which I'll comment on, and then Marge, you can as well. If an employee has completed FMLA paperwork, on file to care for his spouse, can we require the doctor's note for appointments he has to get her to? And I think that's where those intermittent cases that you spoke to, particularly the Oak Harbor case, particularly says no, you can't do that.
And I would also add in, you need to be cautious of the state paid sick leave laws because they're very tough about when doctor's notes can be requested. So this is a situation where it may be more than one law that you need to be concerned about.
Next one, can you relate to FMLA laws when there is a layoff, reduction in force involved while the person is already off work?
So there are no clear-cut guidelines on this. In theory, under the FMLA, if somebody's going to lose their job anyway, then they don't get additional protection. So if there's going to be a general layoff, but you're always at risk that an employee is going to say, you singled me out, that you weren't otherwise going to lay me off, and you singled me out because I've gone on leave. And if you remember that distinction between interference and retaliation, it may be safer to postpone the job action until after the person has come back to work.
Agree, and I think the general rule is you have to treat them as if they never went out on the FMLA leave. So as long as you have documentation to show, notwithstanding what Mark said, which I agree with, as long as you have documentation to say that the employee has would otherwise have been affected in this way, and certainly, for example, a layoff or particularly a shutdown of a location, those are much easier to say, well, everyone in the Topeka location lost their job. It would have happened to Randy too because he worked in Topeka. But otherwise, you need to be very careful of those situations, and there have been cases where it goes to an interference and or a retaliation claim. Okay, another couple here before we wrap up. Let's see. There's so many. I'm getting lost in these. If an employee, this is not. One second. What kind of proof does the employee need to provide to the employer for stress relief time off? So in that one, if first of all, be aware that it's not just, you can't just take time off for stress. It needs to actually be a qualifying disability under the ADA. And although the ADAAA certainly reduced that bar, the employee still needs to prove that they have a disability, and that disability can be certified, again, unless it's obvious, by a doctor. You can have a healthcare provider speak to whether or not that stress actually rises to the level of a disability under the ADA. And then the other thing is the time off still has to be reasonable for the employer. I'll throw another one your way, Marjory. What is new with employer obligations to consider ADA for an employee to care for a family member?
Oh, that is a timely topic. The ADA itself is pretty clear that there is no affirmative duty to accommodate, to care for somebody who you're associated with who has a disability. You are protected from being treated badly because you're associated with someone with a disability, but under the ADA at least, you're not entitled to an affirmative accommodation. Interestingly, in California, an appellate court there recently decided that their state law is broader and that it does require an affirmative accommodation for somebody associated with someone who has a disability. Also, there's a New York City caretaker discrimination law that was recently enacted that prohibits employers from discriminating against those who have caretaking responsibilities. It does not affirmatively require an accommodation, but I think there's a real danger for employers because it's not unusual for you to sometimes allow somebody time off for something, and if you then deny it to the person who's associated with someone with a disability, you could be accused of caretaker discrimination.
And keep in mind, though, those are, and certainly the California case got a lot of press, but those are only for those individual states and for the state analogs of the law. They were not ADA decisions. Okay, let's do one more, and this is sort of a big one. How to handle someone that exhausted FMLA for 12 weeks but needs more time off for reasonable accommodation requests. This is the million-dollar question. How long should you extend the leave? I've heard before up to a year. Is that true?
Well, I'm willing to tackle that.
Okay.
I think when somebody asks for the leave, one of the first things that we do is we send them a memo that says you need to submit medical documentation that indicates what disability you have, why you need, and this is the doctor has to say this, that you have this medical condition, that you need accommodations because of the medical condition, this is why, and this is how long. A lot of times employees get tripped up at that stage. They either don't submit the documentation, or the documentation is no good, or the doctor doesn't back up what they've asked for. So my view on dealing with these things is patience and taking it one step at a time. So that would be my first approach. My next approach would be if they ask for a leave of say 2 months, but you don't believe it's going to be 2 months, you think it's going to be longer, I wouldn't try to bite off more than you can chew. If 2 months if you've allowed other people to have that amount of time, or if it's going to take you that much time to replace the person, that's another place where employers get into trouble, then you may want to allow it. Sometimes it's helpful to allow the initial request, and then you're in a better position to deny the subsequent requests because you show that you've had an open mind, and now it's becoming burdensome. A year seems like a long time to me.
It is a long time, although there's at least one case where the court allowed 17 months, so well over a year of time, saying that's reasonable. And there has been a lot of publicity over the last few years that in those cases that we showed you, those inflexible leave and the slide with all of those cases with many of them with multi-million-dollar settlements, the EEOC is pursuing one and has been for the past 5 years against UPS. And there, UPS had a leave policy that gave up to a year of time kind of automatically. It was only after a year that they said that you couldn't return. And there the EEOC is saying, well, you can't do that. You can't have an arbitrary cutoff, even if that arbitrary cutoff is as generous as a year. I've talked to the EEOC, to trial attorneys at the EEOC lately who said they're kind of all hands on deck right now in litigating that case. So the most important thing is to do the practices that Marjory talked about and not try to look at it in terms of a bright line rule, because anytime you do that with the ADA, you're kind of asking for trouble. I'm going to turn it over back to JC now. I know we had a lot more questions, and I appreciate all of them, but we don't want to bore you to tears with the rest of your afternoon, so we'll end it here.
Yeah, so I know that as Matt said, there's a bunch of questions. Unfortunately, we're running over time. Like I said, please contact IBI if you have any further questions about the presentation, about the speakers, about the IBI forum, or anything that was mentioned in this webinar. We are accessible to you, and you can find all of our contact information on the IBI website. And then just a reminder, we will be sending out the presentation and then the recording to all of the attendees, so you can go ahead and use that for reference in your work. Again, much gratitude to both of our speakers, Matt and Marjory. We like to thank them for presenting at our forum and also participating in this webinar today. And we'd also like to thank the attendees for taking the time out of their day to learn more about how they can better help their workforce. in making sure that all of their policies are legal and that everybody is compliant. And for that, we'll go ahead and wrap it up. And like I said, in a week's time, this webinar should be up on our website. And final thank you to Matt and Marjory.
Thank you.
Thank you.